My name is Shady Louis. I'm here at the Riverside CPS Court. I hired attorney Vince Davis to represent me, and it's a good thing I did. I was here today for trial, and Vince Davis got all the charges against me dropped. And he got the children placed with me, and the case closed. I rate him a 5-star attorney.
Good morning. Good morning. This is Attorney Vince Davis, and this is my daily live stream, my CPS office hours. Today, we are going to call the live stream the CPS War Room 12 Strategies to Take Control of Your Case and Win. Welcome to the CPS office hours, and today, special event. The CPS War Room, 12 strategies to take control of your case and win. This live stream is kind of like a master class, whether your case is just starting in the middle or at the end, near termination of your rights. This is the legal and emotional training you need to survive and win. If this content helps you, please donate to our channel. Like and subscribe, and also consider joining CPS, my Fight CPS School, SKOOL.com, for coaching templates and live strategy calls every week. All right, strategy number 1. Listen, you're not a victim. Now you're a strategist. This is war, not a negotiation. CPS has a very strong and experienced legal team. So should you. I want you to stay calm, stay focused, and methodical. Everything you say, text, post, or miss is part of your case and part of your trial. I want you all to have the winning mindset. You are the CEO of your family and your defense team. So let's start acting like it. I had this talk early this morning on the West Coast. I started texting with a woman who I've been talking to for it seems like months. And she's not a client, but we were always texting each other. And one of the main things that I find with her is that she doesn't have the winning attitude. She has a victim attitude. And I tried to explain this morning to her. You have to have that winning attitude. All right, strategy number 2. You have to understand the battlefield. The court process, detention, jurisdiction, disposition, review hearings, and of course, the dreaded 2-6 hearing. Who's who in the courtroom? The judge, the CPS worker, the CPS attorney, your attorney, the child's attorney. You have to get to know all of these things. And at some point in time, I've done videos about these issues in my YouTube channel. Take a look at it. Become informed. If you have any questions this morning, post it here. Understand what CPS must prove at the detention hearing, at the jurisdiction hearing, at the disposition hearing, at each 6-month review hearing, and then, of course, at the 2-6 hearing. You have to know, you have to understand so that you can assist your attorney, either your private attorney or your court-appointed attorney. The next thing you have to understand is how evidence is used against you and how you can use evidence against the social worker. One of the most important things in any CPS case, any legal case, is how to get in evidence and how to keep out evidence against you. Know the system so you can bend it to your advantage. Last night at my office, I left my office maybe about 6:30 p.m. and I was meeting with someone, with two family members actually. And one of the things I told them at the end of the conversation is every attorney knows the law. Every attorney. You can just open up a book and read it. The difference between attorneys, though, is not knowledge of law. It's their ability to control evidence in a case. Can they get in the evidence that they need? Can they keep out the evidence that's going to be harmful to you? And what are their trial experiences and education? Strategy 3, secure your defense. In my opinion, if you can afford it, you have to hire a CPS attorney, someone that's experienced. Now, what do I mean by experienced? Have they done it 1 year, 2 years, 5 years, 10 years? When I was a 5-year attorney, I thought I knew everything. When I was a 10-year attorney, I knew everything. When I was a 15-year attorney, I realized what a mistake I had made thinking I knew everything. I didn't. So you want to focus on questioning your attorney or your prospective attorney. Hey, how long have you done this? I know one attorney who's like maybe a 20-year attorney. But for the first 15 years of his career, he was a personal injury attorney. And apparently a very good personal injury attorney. And then he started doing CPS cases. Well, he only has about 4 or 5 years doing CPS cases. He's not that experienced. He may feel that he is, being a 20-year attorney with 5 years in CPS experience. But listen, this is much more complicated and involved than you could ever imagine. Next, always get a second opinion before you hire anyone, especially if you believe you have a public defender who is not up to your standards. Start getting second opinions from people, from other experienced attorneys. By the way, and I say this all the time, and this is the law in California, I would imagine and only guess that it's the law in your state. When you get a court-appointed attorney, you expect Johnny Cochran. Well, listen, that's not the law. You get a warm body who generally knows the law. You are not entitled to Johnny Cochran, so don't act like or feel like your public attorney is supposed to be Johnny Cochran. And if you hire a private attorney who's not experienced in this area, and I'm talking like 15 years or more, you don't get Johnny Cochran. All the lawyers in the world in California, we all have a license to practice law. That does not mean we're equal in terms of education and experience. The next thing you should do to help your attorney is start building a timeline of events, contacts, reports, and responses. Next thing you should do is file for discovery. Talk to your attorney about how to do this. There's formal and informal types of discovery. You have to review this discovery, review the responses, review the reports. Help your attorney out. Highlight and comment on where the reports are wrong, or where you can find witnesses or get witnesses to support certain things in the report or disprove things in the report. Here's a pro tip for you, and I rarely see people do this. Bring a legal pad to every court hearing and act like your attorney's paralegal. Bring a legal pad, your notebook, to every meeting with your attorney, your meeting with witnesses on the phone or in person. Act like You care about this case. It's probably the most important case you'll ever be involved with. So get a pen, go buy, a 99-cent spiral notebook from Walmart, and let's keep it together. Let's keep those notes. Let's review those notes frequently. Strategy 4, master the evidence game. Save and organize your drug test results, your class certificates, photos of your home inside and out. Save your communications, your text messages with witnesses, with social workers. And while you're at it, get some letters, some character type letters from teachers, pastors, doctors. Record every effort you make to reunify with your child. Some people will tell you that, like in California, character evidence is not admissible. That's the general rule when you get these letters. However, there are exceptions to the character evidence rule. It's been my experience, maybe 50-50, that judges will let in or keep out character evidence. But at least you can give those to the social worker. And if you try to introduce them into evidence and the judge doesn't consider it, at least it's part of the record. There's at least one evidence guru in California, Bernard Jefferson, who's written a treatise on California evidence. It's called the California Evidence Bench Book, or Bench Book on Evidence. And he opined that character evidence is generally inadmissible, but it is admissible anytime character's at issue. And he opines that in every juvenile dependency case, character is at issue. The issue being, are you a fit parent? Strategy 5, try to flip the narrative. Reframe your story from the court's perspective. Let me give you an example. You're not a struggling parent. You're a recovering warrior. Show the court and so the social worker that you have participated voluntarily in the classes, in the counseling. Show that you have community support from friends, relatives, family members, church members. Show that you have stable housing and income to support yourself and the children, or get that from public assistance, or get it from family members. So it's up to you to control your brand in the courtroom. Right now, let's take a quick break from this strategy session. Make sure that you're dropping your questions in the chat. If you learned something already, please consider donating to support this free content. Or better yet, join my Fight CPS School, SKOOL.com, where you can take this deeper every week. So don't start dropping your questions in the comment section, because at the end of this, I'm going to do a question and answer session. Hopefully it can go on longer than usual. It's Saturday morning and I don't have to be at court today. Okay, strategy 6. Take control of your visitation with your children. Show up every time you have a visit. Never miss, never be late. Considering bringing things to the visit. For example, a bag of food, snacks, games, activities. Just don't show up empty-handed. Avoid conflict at these visits. Be joyful and focus on your child. Forget the social worker who's monitoring you. Don't necessarily get involved in conversations with them about the case. Focus on your child and the visit. You need to track in your notebook the dates you visited, the length of time of the visitation, who supervised your visitation, and what happened at that visitation. You're going to see in reports, negative reports of visitation you had with your child. And if you don't remember and don't have it documented to prove that that's false, you might be in trouble at one of the review hearings. Remember, every visit is a courtroom demonstration for the judge. Let me repeat that. Every visit is a courtroom demonstration for the judge. Remember that and act accordingly. Chapter 7, beat the case plan game. Start services before the court orders them. Ask for modifications if the plan is unrealistic. Submit completion of documents early. Push back if services aren't offered quickly. Services being offered to you is required by law from the very beginning of the case. Now, I had an interesting meeting yesterday with some relatives, and the relative opined that why should my son, the father, start doing counseling or domestic violence or parenting? He's innocent of all charges. I agree. I believe you. He is innocent of all charges. However, as this title of this strategy number 7 is beat the case plan game, this is a game, a certain type of way courts and the system looks at you, whether you are guilty or not. Let me give you an example. Let's say you were accused of domestic violence and you proved that you weren't the perpetrator of the domestic violence because you were at work when it's claimed that you had committed these acts. All right. In the judge's mind, and by the way, this is just my humble opinion after doing this almost 40 years. In the judge's mind, you may get credit. In other words, you may be more credible in your testimony if you've also participated in services that the social worker was recommending. Before the jurisdictional phase of the case, do you have to do those services? Absolutely not. And that's the question most people ask me. Do I have to do those services? Absolutely not. Not before the jurisdictional hearing. But the question they should be asking is, should I do the services? That's a whole different conversation. So remember, own the case plan. Don't be owned by it. Okay, strategy number 8. Expose CPS failures. Keep a list of missed visits, no callback, and failed services. And by missed visits, I mean when the social worker or the foster parent canceled your visit. You wouldn't believe how many times we get calls from clients who say the social worker or the foster agency didn't bring the child to the visit. At the last minute, they claimed, oh, he or she was sick. At the last minute, they claimed, oh, they didn't have anyone to monitor your visits. Keep track of those because you will be entitled to make up visits. Now, if you miss a visit, it will be used against you. If they miss a visit, keep track of it. We want to mention this to the judge at a certain point in time, and you need to get your makeup visits. You can file complaints through internal grievance systems at the county level, the state level, and at the federal national level. So consider doing that as well. I'm in the middle of a case right now where they are treating the parent so bad, my client, that we're making motions to try to get back in court, try to hold the social worker in contempt. And we're also making complaints at the national level with the Department of Health and Human Services, the U.S. Justice Department Civil Rights Division. All right. We're not going to let things go unchecked. And we're going to try to hold the social worker accountable. They're trying to hold you accountable. You can hold them accountable. Ask your attorney to request sanctions for unreasonable efforts. The odds are the judge is not going to allow you to have sanctions. Have I ever heard of it being done? Yes, I have. It's not the usual course, even though maybe it should be. But at least make those requests, because even if the judge doesn't give you those sanctions, It'll be on record, and he or she will remember that when it comes time for issues of making a credibility finding for or against you. Social workers that don't follow orders and social workers that interfere with your reunification, such as your visits, in the back of the judge's mind, it's been my experience that they remember that. And when it comes time to decide who's more credible, you may get the nod. You want to try to get every advantage you can in this war. So the key takeaway, make the court question CPS's credibility, not yours. All right, strategy 9, use the law as your weapon. Key laws to research. You don't have to write this down. It's going to be on, this platform forever. You can rewatch it. Welfare and Institutions Code Section 300, 361, 388, and 366.26. Those are the sections in the California Welfare and Institutions Code. You can Google it. You can just look it up. Or you can find the similar or same statutes in your states. Because by federal regulation, every state has laws that are similar to this. Next key law to remember, 42 U.S.C. Section 1983. It's the civil rights statute that covers every American citizen, it covers every person in the United States that has one of these cases. So whether you're documented or undocumented, whether you're a citizen or not a citizen, you still have rights. You still have civil rights that the social workers cannot violate. Next thing to Google and read, the U.S. Constitution, the 4th Amendment and the 14th Amendment. You have rights to protect you from unreasonable search and seizure, taking your child. You have rights of due process. Social workers, judges, they all have to respect your rights, your civil rights. All right, use these statutes and these laws to support every motion and complaint you have. Talk to your attorney about how to do that and how she or he will do that. Key takeaway, real legal citations show the court you're not passive and that you will do something if unfair decisions are made. You'll do something like appeal or make motions or continue to ask for court intervention. All right, strategy 10, build a defense file for the judge. You should do this in conjunction with your attorney. You need to assemble and gather your proofs of services completed or participated in, your clean drug test, photos of you, of the child, logs. You're logging and reviewing and recording all of your visitation, all of your classes, your therapy sessions. You want to get this child's school and health records. Deliver a package that says, this parent is serious about this case. Judges, remember preparation. Let me repeat that. Judges, remember preparation. And it's a key way to gain credits and credibility with the judge and sometimes the social worker. All right, strategy 11, reunify or appeal, but never quit. If reunification is denied, file an appeal. Ask for the writ. File for relative placement, which should be done early and often. If your rights are terminated, prepare for post-termination appeal. Consider a federal civil rights action. You only lose if you stop fighting. There's one thing I want you guys to consider. I get a lot of calls from people A great number of the calls are for people that have already lost their parental rights. Now, can something be done? Maybe. Likelihood? No, nothing can be done. Don't wait until you lose your parental rights to call or look for an attorney to help you. Start early and call often. I spoke to a couple yesterday, and they told me that they had been watching my YouTube videos for 2 years. And from talking to them, they were telling me about videos that I had done, videos that I had even forgotten about. And it became apparent to me that, yeah, they've been watching my videos. And next month they're having a hearing to terminate their parental rights. I won't tell you about the facts of the case, and of course I can't mention their names, but I started wondering why they waited 2 years to call me, to even get a consult. You know, when you call me, you don't have to call me with the intention of hiring me. Maybe you just want some free advice. Maybe you want a book, for, a paid consultation. But to know about me for 2 years and not call me until you're a month away from losing your parental rights, that's like shooting yourself in the head. And I asked the mother, I said, look, I got to ask you, if you've been watching every video I've done for the last 2 years, why are you just now calling me? You know what she told me? And I hear this a lot. Basically, Mr. Davis, this is America. We're supposed to be treated fairly by our government officials. And I always gave the social workers the benefit of the doubt that they would do what's right and do what's fair. Don't believe that. Don't believe that, or don't take that chance. You don't know what's in the social worker's mind. You don't know what the agenda of the social worker is. Take precautions early and take precautions often. Remember, you only lose if you stop fighting. Strategy 12. Win or sue. Either way, continue the fight. If CPS broke the law, contact a civil rights attorney. Request damages, money damages. Try to get your child back. Share your story publicly and legally. Let me repeat that. Share your story publicly and legally. When you share and the world knows what's going on, you are making change. Remember, I learned this in law school, my first year of law school. Justice comes from persistence. Justice comes from persistence. The fight for your children is the most important lawsuit you'll ever be involved in. So we've completed this masterclass in the CPS War Room. You now know 12 ways to take control of your case and win. If you want templates, legal language, and weekly guidance, join my Fight CPS School, skool.com. And if you believe in what we're doing here, please donate to help us help more families and to keep this channel and this platform open. I'm Attorney Davis. Stay sharp and powerful. And of course, we'll see you tomorrow at our CPS office hours, 6:30 a.m. Pacific Standard Time. I want to tell you guys that I have sent a PDF handout for this masterclass we did this morning to my producer, Grace. And I'm going to ask her to post it on all of the platforms we're live streaming to right now. I think we're streaming to about 8 social media platforms. So hopefully later on today, when she starts at 8 o'clock a.m. today, sometimes by noon, hopefully that handout will be posted. So come back and check and see if they've posted it so you can download it. All right. Before we leave, let's take some questions. If you have questions and answers, post them now in the comments because I'm going to try to go through them. All right. On YouTube, the micro team says, "Good morning, Mr. Davis." Good morning. Kind of hard to get these comments. Okay, Tony Tiger from YouTube says, "I'm facing negligence charges because my son was brought to the hospital by the cops and they saw they wouldn't let me take him home to the point they started isolating him. So I called the health department. The CPS hotline of the hospital, then I had to get a lawyer who threatened to go to court. They still wouldn't leave. And she drew up papers for the Supreme Court next day. Let me take him. Tony, hi. Tony, I'm a little. Oh, here it is. You continue. They let you take him home after they filed the neglect charges on me. Yet I wasn't able to be in the court because supposedly all same conversation CPS said they could not find me. Then they said after I live in building, that needs a code key. They knew exactly where I was, so they purposely violated my due process. Neglect is based upon domestic violence found at reports from 10 years ago. One report names all. 3 children, yet my son wasn't born until July 22nd, 2011. By the way, I'm here from Otsego County, New York. Okay, Tony, interesting question. A little interesting story. I was a little confused, but I'm not sure what your question is. Good morning. Okay, Margaret King, member of my YouTube channel, says, "Good morning. Are the audio recordings and videos during every visit with the children available and admissible?" That's an interesting question because a lot of social workers say that your video, your recordings or your visits aren't recorded. But I happen to know that in a lot of cases that's not true. And Margaret, in your case, in your particular county, I won't mention where, I believe they do visit them. I mean, they do record them. In a case in Riverside, probably a year ago, I tried to get a hold of those tapes, and they fought like hell not to give me those tapes. And one of the reasons is because the parent told me, my client told me the visits were great. But when you read the social worker's report, who wasn't even at the visit, was being monitored by some assistant of the social workers, the the description given by the social worker in the report was a negative visit. So maybe before visits should start, you should get, or your attorney should get a sense on whether the tapes, the visitations, or audio or video recorded. One of the things I've done in the past, or seen done in the past, is that you get a court order that you can audio or videotape your visit. Obviously, the social worker is going to say ABC, and reality is going to be XYZ. What better way to prove to the judge that you're telling the truth and not the social worker by getting an order that you can video or audio tape your visitation? Margaret from YouTube also asked, "Can I bring my therapist with me as a witness for the JV 183 hearing?" That's a good question. The answer is you can, but you're probably going to need a court order to do it. Most social workers won't let you do it, claiming, safety for the child or best interest for the child, which is all BS. But this is evidence that can help you at your hearing, Margaret. Margaret goes on to say, "I am saving a private therapist." Saying or seeing a private therapist. She's certified in domestic violence, anger management, and trauma, etc. CPS wants me to go to their own people. So one of the things you have to do, Margaret, is to get the qualifications, the resume, the CV, the curriculum vitae of your therapist to show that he or she is qualified to be a therapist in this case. Of course, CPS wants you to go to their own therapist. They're going to claim that that person is more qualified than your therapist. And they also know, or we also know, that your therapist is being, or their therapist is being paid by them. Who do you think they're going to come down on the side of? KK Richardson from Facebook. Good morning, Mr. Vincent Davis. Good morning. Good morning, Kay. Susan from Facebook. Can you do a step-by-step guide to how to file a national complaint? Local level complaints in our case went nowhere. Suzanne, I'm not sure what you mean by that. Maybe you can give me a call at 888-888-6582 and I can get a better feel for what you're asking for. I don't know if you know this, Suzanne Green Atkins from Facebook, but I'm in the process of developing an online course on how to sue a social worker. So that might be something you might be interested in. KK Richardson says, I'm so lost. There was a finding, quote unquote, on Wednesday. KK says, technically, I was found guilty of neglect based on inadequate evidence. All right, KK, welcome to my world. Margaret from YouTube, when is the appropriate time to request a change of lawyer for the children? That's a very interesting question. It usually doesn't come up or doesn't happen, but you can do it. You can do it at any time. You can do it by way of motion. However, Margaret, remember, when you make a motion like that, you got to have evidence. All right? Margaret says, my last question, why is CPS filing in JP 183 and conducting a CFT meeting on May 12 and only notified the resource parent to attend when the case is in the appellate 5th District Court of Appeal? Margaret, I can't tell you why CPS does what CPS does. They don't consult me. There could be a million reasons on why they're trying to do that. Tony Tiger from YouTube. I don't know, but from what I've seen and heard lately, online in-person experiences, CPS especially here in Otsego County, is using their status to traffic kids. I'm getting neglect charges for getting a lawyer and getting my son back in my home because A.O. Fox Hospital Emergency Department wouldn't let my son come home when he was first brought to, hold on, when he was first brought to the hospital, they used excessive force and did to my son based on his demeanor while therein when I finally got him out. He was definitely abused many ways. I got your link for the consultation, but is there a time limit to suing a CPS social worker? The answer is, Tony, yes. There's always time limits, everything in the law. In California, to sue a social worker, it's generally 2 years. I say generally 2 years. But in your state of New York, I'm not sure what the time limit is. You're going to have to find that out by doing some research or better yet, talking to a lawyer. Okay? All right. Tony says, what can I do about them lying, unable to find me so I could be at the initial court hearing? Isn't that a violation of my due process? Absolutely. And your remedy is to bring a lawsuit and ask for damages against the social worker and or the state and or the county where you're living there in New York. All right. I've covered all the questions. Nobody has any other questions. Don't forget, check back in a few hours and you'll find a template for today's master class on the 12 strategies. And everyone stay safe. I'll see you tomorrow at 6:30 a.m. Pacific time for another session of our office hours.
When I was interviewing attorneys, one of the attorneys told me Vince David was retiring and he didn't know what he was doing. That was a competitor of Vince's. I knew the part about Vince not knowing what he was doing was false because I had seen his YouTube channel. That attorney that told me that was a competitor and a liar. Vince Davis was masterful in the court.